Good morning. This is the Administrative Law Judge. Do I have Heather Bell on telephone?
Yes, Your Honor. Good morning.
Hi, Ms. Bell. How are you doing?
Good, thank you.
Ms. Bell, do you have your witness in the room with you?
No, Your Honor. They're appearing by phone as well.
Okay. And are you going to have only one witness?
I have two witnesses. I have Susan Larson, and I also have Mariah Forrest.
Okay, and for your information, Ms. Bell, I'm in the hearings room, and I have Mr. and Mrs. Kuhn in here with me. I also have Charisma.
Thank you, Your Honor.
And I have you on speakerphone.
Okay.
And is Ms. Larson on the telephone line? Okay. Ms. Bell, I only picked up that you and I were on the conference bridge right now, so we'll give Ms. Larson and Ms. Forrest a few minutes to appear. And can you hear my voice okay, Ms. Bell?
Yes.
Good morning. Would the caller please identify themselves?
This is Mariah Forrest with the Office of Developmental Disability Services.
Good morning, Ms. Forrest. My name is Eric DeLugan. I'm the Administrative Law Judge this morning.
Good morning.
I also have Heather Bell on the telephone with us, as well as the Kuhns.
Okay.
I believe, good morning. Was that Ms. Larson that just joined the telephone conference?
Yes, this is her.
Good morning, Ms. Larson. My name is Eric DeLugan. I'm the Administrative Law Judge.
Loud enough?
Yes, I can hear you.
Right.
Okay, so I believe everyone's present now, so we'll go ahead and begin. This is case number 2014-0643. This is a community-based waiver services hearing for Charisma Kuhn. As I said, my name is Eric DeLugan. I'm the Administrative Law Judge assigned to this matter by the Office of Administrative Hearings, which is a body of administrative law judges independent from the Department of Human Services. Today's hearing is being recorded. It is May 5th. The time is now approximately 9:04 a.m. I have appearing in person Renee Kuhn, who is the claimant's representative and mother. I also have Mr. Kuhn. I'm sorry, Mr. Kuhn. What was your first? Gary. Gary. I also have Gary Kuhn, who is the claimant's father, in the room with me. Appearing by telephone representing the Department of Human Services is Heather Bell. Also is appearing as witnesses for the department are Susan Larson and Mariah Forrest. It's my understanding that the issues for today's hearing is, first, whether the department may reduce claimant's community transportation mileage, and two, what is the correct amount of community transportation mileage which claimant is entitled to. Ms. Bell, are those the issues as you understand them?
Yes, Your Honor.
And Ms. Kuhn, are those the issues that, as you understand them?
Those are not the issues.
What other issues?
Well, we're here because of the rationale that was used and was given to us both verbally and in writing in order to reduce those miles. Yeah, that violated OAR's numerous. So yes, it's the rationale to reduce those miles that I have a problem with.
And I just want to tell you, Ms. Bell, and the Kuhns, that I'm going to be taking a lot of notes this morning, so there may be a pause, or pauses in between my questions. So please bear with me. And Ms. Bell, did you hear Ms. Kuhn's identification of the issue of the rationale behind the department's decision to reduce the mileage?
I do, Your Honor. I would just argue again that the issues here for this hearing are if we may reduce the mileage and what that mileage is. We set a notice, and that's the reason why we're here, is based on our notice of planned action. We typically don't give hearings unless it's a snap case on rationale, or if people feel that the reasons were unjust, unless they're asked. The issue is the mileage and what the mileage should be.
Go ahead, Ms. Kuhn.
The decision to reduce the miles had already taken place in advance of any notice of planned action, which I have evidence, hard evidence to prove. And that decision was placed into Charisma's new plan without any prior notification as a surprise on February 24th. And the justifications that were given for that mileage reduction on February 24th were absolutely false. And I stated that immediately on February 24th and told them that I could not sign that plan with false statements about my daughter included in that plan, which she told us were justifications for the mileage reduction. Action appearing in my daughter's plan was our notice.
Okay, I'm not going to rule specifically on that final issue that you raised at this time, but but I will address that in my order. Ms. Bell, is the department requesting a final or a proposed order here?
A final order.
Okay, thank you. And next we'll review the exhibits. I have in my packet what's been marked from the department as exhibits A1 through A19, as well as an amended exhibit A1. Ms. Bell, are those all the exhibits that the department has submitted?
Yes, Your Honor.
And does the department wish to have these documents entered into evidence this morning?
Yes.
And Ms. Kuhn, have you received copies of these exhibits?
Yes, I have.
Do you have any objections to these exhibits being entered into evidence? Okay, there being no objections, exhibits A1 through A19 are admitted into evidence, and either party may reference those exhibits in their testimony this morning. And Ms. Kuhn, I have from you exhibits C1 through C30. Are those all the exhibits that you submitted for today's hearing?
Yes, they are.
And Ms. Bell, do you have exhibits C1 through C30?
Yes.
Do you have any objections to any of the exhibits?
I do, Your Honors. Other than some of them being duplicate of our exhibits, I do object to C14, C15, C16, and C19 on relevance. They're irrelevant.
They're not irrelevant.
Okay. Okay, it appears exhibit C14 is the behavioral support plan dated July 27, 2005. And Ms. Bell, specifically, why do you find this document to be irrelevant?
Because it's dated July 27, 2005, and it doesn't address community mileage in it.
And Exhibit C15, Ms. Bell, could you be a little bit more specific as to why you find this exhibit to be irrelevant?
This again doesn't address community mileage. This is her in-home case plan. It addresses her care needs, but again, not community mileage.
And Exhibit C16, is that also the relevancy objection based on the fact that it doesn't address community mileage?
Yes, and the date of the assessment is actually 2011 on that one.
And Exhibit C19, is that also same rationale?
Yes, and it's not signed. Your Honor, I realized that there was other additional stuff attached. I withdraw my objection to C19.
Okay.
It does address community mileage in it.
Okay, thank you. And Mr. Kuhn, what is your response to the department's objection specifically to Exhibit C14?
Is that Susan Larson, our caseworker, February 24th, referred to as the data that she included in that unsigned plan that justified the mileage reduction. She took language from a document 9 years old and included it in Christmas' new pay plan in 2014 and used that as justification for the mileage reduction. It's very relevant. And the reason I have the behavioral support plan is Susie Larson herself faxed that to me on March 14th when I said, send me a copy of that behavioral support plan that showed that data that I said was false. And she herself faxed it to me. So I have it because she gave it to me and because it was referenced on February 24th.
And Exhibit C15?
Okay. C15 is the adult in-home support assessment. There's 3 pages there. That was Christmas' most recent assessment. It's incredibly important. It was used to justify whether Charisma qualified for a new pay plan that we were supposed to sign on February 24th. Instead of drawing data from Charisma's 9-year-old behavioral support plan, that's the assessment that she should have drawn data from.
And Exhibit C16?
Okay. And that is just a cover sheet of another recent assessment that she could have went to get data to create Christmas new pay plan on February 24th. It was done in 2011. She ignored the assessment that was done in 2014, 2011, and went all the way back 9 years to pull data that is absolutely false and untrue, and making it so that I could not sign that official document.
Okay, Ms. Bell, I'm going to reserve until the end of the hearing to rule on the admissibility of C14 through C16.
Your Honor, I'd also like to address Exhibit C28 as well. And I just wanted to make it clear that that is not testimony. That's a copy of an informal conference. I don't believe it's relevant to this hearing. We have informal conferences all the time. However, again, I just want to make it clear that it's not testimony. I have witnesses that can provide testimony on the line.
Okay. And I'll also address whether I'm going to admit C28 into evidence at the conclusion of the hearing. I did want to address Exhibits C through C12. Those appear to be excerpts from the administrative rules.
What was the number?
C2.
Oh, C2 through 12.
Yeah.
Yes.
Okay. These aren't exactly proper to admit into evidence, but that's fine. So I'm not going to admit those into evidence, but you're free to reference the administrative rules in your arguments. Also, Exhibit C25, I think the department has already, those are the mileage logs.
Yes.
And I believe the department submitted those in Exhibits A9 through A14.
Mm-hmm.
So, because they'd be duplicative, I'm not going to admit C25 either at this time. Okay. At this point, I'll give each party the opportunity to make an opening statement. Ms. Bell, does the department have any opening statements they would like to make?
No, Your Honor.
And Ms. Kuhn, do you have an opening statement that you'd like to make?
Yes, I do.
Okay, please proceed. And you might want to, if you can, speak up a little bit. I'm not sure.
Okay. Well, why don't I stand up a little bit, project a little bit better.
Ms. Bell, if you have difficulty hearing us, please let me know.
I'm here today, Your Honor, because of OARs that were seriously violated by Madison County in an attempt to justify a 53% reduction in Christmas community transportation benefit from the current 779 miles per month to 360 miles per month. I will prove beyond a shadow of doubt today that without any prior notification in any form and without any input or approval from Christmas legal guardian, her father and I, Susan Larson, DDA 2, Christmas caseworker of 9 years, willfully and with intent chose to place written statements in Prisma's new K plan that falsely represented her level of functioning and preferences in an attempt to justify a significant reduction in her mileage benefit in her new K plan that I refused to sign on May 24th due to those false statements. Our position is that Prisma's full mileage benefit of 779 miles a month, set to expire on June 30th in her current ISP, will remain in her new K plan until such time that Marion County can give us a legal and truthful reason, backed up by applicable, relevant OARs, before reducing or eliminating that benefit. In addition, I will prove that exhibits presented by the department contain gross misrepresentations of facts, irrelevant and unrelated OARs, and hearsay. My testimony with supporting evidence will verify that rules guiding the use of Christmas mileage benefit were met by us, and that she is entitled to continue to receive the full mileage benefit that she was originally deemed entitled to receive by Marion County.
Is that everything?
That's it.
Okay, thank you. Okay, so next I'm going to go ahead and begin with the department and allow the department to present its case. Once the department's witnesses have testified, Ms. Kuhn, you have the opportunity to ask them any questions that you may have. But there will be an opportunity for you to ask questions, not to introduce any arguments or evidence at that time. If you disagree with something the department's saying, it may be better, if you want to rebut what they're saying, is to wait until your testimony to argue. I just don't want it back and forth arguing. It's only to...
So when she brings Susan Larson by,
right.
I can ask her questions, any question or something regarding what she was asked, or what is
You can ask questions in regards to the issues here this morning.
Okay, and then I have another question, is how am I sure that she's by herself with no one guiding her answers?
Okay.
Ms. Larson, yeah.
Sure. Okay, I'll address that. Ms. Larson, can you hear me?
Yeah, I can hear you.
Okay. Do you have anyone in the room with you?
My supervisor, Dawn-Alisa Sadler, has joined me.
Okay. And is Ms. Sadler going to be presenting testimony this morning?
No, she is not.
Okay. The claimant has requested that Ms. Sadler not be present. So, Ms. Larson, would you
She's just here for training purposes. I'm comfortable doing it without her if you need me to.
Is that what you would prefer,
Yes,
Ms. Kuhn?
yes. And is she sworn in?
Yeah.
Right, she'll be sworn in.
Sweet. Okay, because the claimant has requested that Ms. Sadler not be present during your testimony, Ms. Larson,
Okay.
I think for the time being, Ms. Sadler can be present during the hearing. However, when your testimony begins, if Ms. Sadler could leave the room.
Great, we can do that.
Okay, thank you.
Sure.
Ms. Feld, do you have any questions before we begin?
No, Your Honor.
Ms. Feld, will you be providing any testimony?
I will not.
Okay. And who would you like to call as your first witness?
I will call Susie Larson.
Okay, Ms. Larson, if you could please raise your right hand. I'll place you under oath. Under penalty of perjury, do you swear or affirm that the testimony you shall give in this matter shall be the truth?
Yes, I do.
And could you please state your name, your full name, and spell your last name for the record?
My name is Susan Larson. My last name is spelled Larson.
Ms. Larson, who are you employed by?
County Health Department, Developmental Disabilities.
And what is your position there?
I'm the Developmental Disability Associate 2.
Could you briefly describe your job duties?
The major job duties of a case manager are to meet the service needs of an individual and in an emergency or crisis. Specifically, I assess individuals' needs and develop an ISP and an annual plan, and I monitor services and supports and facilitate entries and exits from programs, and I assess and identify plans and monitor crisis services, and I provide information regarding developmental disability services available from other agencies.
Okay, thank you, Ms. Larson. Ms. Bell, you may proceed with your questions.
And how long have you held that position?
I've been with the county for 14 years and 8 months, and I've acted in this capacity for approximately 12 and a half of those years.
And what training and education do you have to be a case manager?
I have both an associate's and a bachelor's degree in psychology. I've worked for the state of California as an individual program coordinator. I've been a job coach, a direct care staff, and a house manager, and I was also a community activities assistant in the state of North Carolina.
And as your job as a case manager, have you worked with Charisma Kuhn and her family?
Yes, I have.
What have you done in sort for them specifically?
In 2005, I admitted Charisma to a foster home and provided the foster home case management for the duration of her stay there. I assisted the family to transfer her to a new adult foster home and case managed her in that placement for a few years. When she transferred to in-home comp, I assisted her in setting up these services and developing the plan. I provided her with in-home comp case management, and recently I assessed Charisma's needs through the adult needs assessment and created the proposed ISP and annual plan.
Have you received exhibits for today's hearing?
Yes, I have.
Specifically, did you create Exhibit A3 and A4?
Yes, I did.
And also, did you review Exhibits A9 through A15 as well?
Yes, I did.
And what did you observe with Exhibit A9 through A15?
I observed that some of the activities did not appear to be allowable as billable mileage, and I wanted to note that This used to be a normal function of my job when the timesheets came in and the mileage sheets, but a few years ago, the county delegated this task to a management analyst. But in preparation for the ANA and the ISP, I reviewed the entire filage to include the entire file, and then that included the mileage and the timesheets, and that's when I became concerned about the possible misuse of mileage.
And after you reviewed the exhibits, what did you do next?
I consulted with my supervisor.
And why did you staff with your supervisor on this?
Well, I wanted to make sure that I was correct with my interpretation of the rules about mileage.
And did you also consult with DH policy on mileage issues?
Yes, my supervisor and I consulted with DHS policy together.
And is that documented in Exhibit A19? I'll wait for you to turn the page to that exhibit. And then specifically page 23.
Yes, that's the mileage.
And that goes through page 25.
Yep.
And after you received that email from DHS policy, what did you do next?
I prepared and sent out the notice of planned action.
And is there anything else you would like to add?
No, I don't believe so.
I don't have any additional questions, Your Honor.
Thank you, Ms. Bell. Ms. Larson, you referenced the rules about mileage.
Yes.
Could you direct me specifically to which rules you were relying upon?
Well, I guess that I would have to spend some time researching that because I don't have it in front of me. I do have OARs with regard to in-home comp. If you want to give me time, I can look for it. When I was referring to the rules, I guess I was just referring to what we know to be true regarding the use of mileage and using it for things that are relevant to the individual and what's in their service plan.
So specifically, why did you reduce the mileage?
Well, by my calculations, I've known Charisma for 5 years and 9 months with a break in between, but what I knew to be true or what I had been told in reading behavior support plan, old ISPs, and talking with the providers that have provided services over the years, and the family, being out into the community for long periods of time was always a struggle for Charisma, and there were references to running errands were difficult for her, and so in looking at those claims on mileage, it appeared that was what the mileage was being used for at times, and that wasn't something that was enjoyable for Charisma, and some of the activities appeared to be activities that would have happened regardless of whether Charisma was along or not. So I just wanted to make sure that it was being used in the way that it's intended.
I think I'm going to have some more questions for you, Ms. Larson, but right now I'm going to allow Ms. Kuhn to ask her any questions that she may have.
Susan, describe for us today what you know about Charisma, her disabilities, her abilities, and her family life. Just a general statement. What do you know about her after 9 years of being her caseworker?
Well, she requires a lot of support. She likes her routines. She has the ability to have, significant behaviors if she doesn't have people that work with her that know her well. She has a lot of support from her family. You guys have done a lot of research and supported her in trying a lot of different methods to manage her her constipation issues, her allergies, her lack of sleep. You've got, found a lot of natural ways to address these things rather than giving her a lot of medications. She has a lot of family support, and you guys are really dedicated.
What was that last thing I didn't hear, that last sentence?
You guys are really dedicated to meeting her needs?
Okay, thank you. Chrissy just made a noise at that time and I didn't hear it. How would you rate Charisma's quality of care that she received from her family, Susie? Poor, fair, good, excellent, or outstanding?
Well, I would say outstanding.
Okay. When did Charisma have her last assessment?
Are you talking about the ANA?
Just any last assessment that you were a part of, Susie. What was the date of that assessment?
I'm not sure I have that date in front of me, but I'm looking through my paperwork. I would say it was probably in January would be my guess.
Yes, you're correct. January 2014. Susie, tell the judge, why did Marion County offer Charisma a mileage benefit?
Well, my records reflect that we talked about a mileage benefit initially back in when she started in-home comp. I guess that would be 2009. I'm not sure. And my case notes indicate that we discussed that, and it was decided that we would see what her plan looked like before you chose to use mileage, and you didn't choose to use it at that time. So then,
Susie, I'm specifically...
Please just let her
answer.
Yeah.
Okay, got it.
So back several months ago, I guess it was probably about July, August, there was a revision to Charisma's plan, and there ended up being extra dollars that were no longer being utilized because you became one of her primary providers, and so it changed due to tax reasons. So there were basically extra dollars, and so when we discussed what other options were available in her plan, mileage came up, and that's what you guys chose.
Okay, thank you. So it was a benefit we never asked for, but it was offered to us because of there was extra funds in Charisma's plans because of calculation error. Is that correct?
Not calculation errors, but it shifted the funding when it went from other people being her primary providers because we had to charge taxes and, there's different rules. And then when you became the primary provider, it made like a gap in the funding, or not a gap, but there was extra.
Okay. So then tell us, Susie, how did Marion County determine that 779 miles a month was the appropriate and cost-effective number of miles to give Charisma to use each month? How did they come up with that number?
That was how much money was left over.
Okay. All right. Now, if you have do you have my evidence packet there too, Susie?
I do not.
She does not.
Okay. In Exhibit C13, C, these are in your case notes, Susie, where you document for the very first time on January 6th that you had already made a decision to reduce Charisma's mileage back to 360 miles a month, and that you were going to explain this change to the family at the ISP meeting.
That's correct.
All right. So my question for you is, why did you violate OAR 411-330-0050, 5, small a, where it requires that you give prior notification for any changes in Charisma's plans?
Well, I guess I considered the prior notice before it was implemented would have been at the ISP. I that's when I present the plan and we discuss it as a team, and it's either approved or not approved. And at that point, then we do the notification and whatnot.
Yeah, that's not the way the law reads.
I object. That's not a question.
But, yeah, I'm going to abstain your objection, Ms. Bell. And, Mr. any argument you want to make in regards to the law, you can make during your testimony or your closing statement.
Okay. Yeah, so the question here, yeah. So you're telling me, Susie, that you didn't know that you were supposed to give prior notification when on January 6th you had discussed Christmas mileage with your supervisor, Dawn-Alisa, and you two together, your case notes say that you had reviewed things that together came up with 360 miles? You didn't know at that point that making decision that you put in writing that you're going to tell us at the ISP that we should have been notified some way, shape, or form that decisions like this and discussions like this were going on behind our back?
I'm sorry, behind your back. So I guess it was my understanding that you present to the team, and if there's objections at that point, that's when we do the notification that the guardian or the individual, whomever signs ISPs, decides that the ISP, no, this is not, this isn't okay with me, and so I want to challenge that, and at the same time we do the notification of planned action. That was my understanding.
Susie, in that same case note on January 6th, I'm going to read what you wrote here. In preparation of Christmas ISP later this month, I reviewed her file again. I noted that some of the mileage that was being billed for appears to include running errands, going on family trips that don't appear to be for Christmas benefit. I sat down with my supervisor, Dawn-Alisa, and we reviewed them together. We agreed that some of these expenses may not be allowable under IHC. We reviewed the sheets closely, came up with an average of miles. My question for you, Susie, is between, we've got you and Dawn-Alisa on that ISP team. What are the other people that are missing from that ISP team that needed to be consulted or questioned about any concerns you had about that mileage?
The other members of her ISP team are you and your husband and Charisma.
Exactly. So in January 6th, you sat down with your supervisor and you made assumptions based on interpreting my mileage logs without ever picking up the telephone, sending me an email, or anything else prior to February 24th when you had already made the decision to reduce her miles based on what appeared to you to be misuse of funds. And then on February 24th, you had already included it in a plan that you expected me to sign. Is that correct?
A proposed plan, yes, ma'am.
Thank you. In the 6 months, Susie, that I have been submitting mileage logs to Marion County for transporting Charisma prior to February 24th, who at Marion County has contacted me regarding a single concern anyone had about where we were taking Charisma, who she visited, or what ISP goals we worked on while out in the community?
I am not aware that anybody's contacted you.
Okay. On February 24th, at the signing meeting of Charisma's new K plan, when I asked you why Charisma's miles had been reduced, what did you tell me?
I told you that we reviewed them and it looked like there were things that weren't allowable to be billable mileage, and that the things that we have talked about and are in our plan are the things that I know to be things that are valuable for Charisma to do, things, activities that she spends her time on. And those are the things that...
Susie, very specifically, there was a sentence that came out of your mouth that you spoke to me when I asked you that question, when I was stunned to see a 53% mileage reduction when we had not had any conversation or any notice. What did you tell me was the number one reason that you reduced Charisma's mileage?
I'm not certain what you're referring to.
Okay. All right. Well, I have a witness who will testify to that, so we'll go ahead and go on. I'll just refresh your memory a little bit. A short, intense discussion ensued after you told me what you said. And at that point, Susie, what did you do next? What did you do next to help me understand why the mileage had been reduced? Did you direct me to a certain part of the plan? Did you say something else? What else? There were quite a few further discussions that took place. What else did you use to justify the reduction of the mileage to us that day on February 24th?
I don't recall what happened next. We spoke on the phone, and
so I'm talking about specifically in that meeting that was very intense. What else did?
Your Honor, she said she didn't recall.
I don't recall. You gathered your stuff and said you weren't going to sign, and you left. I don't recall there being much discussion. It was pretty hurried.
All righty. Let's see. Susie, let's see here. You've been Christmas caseworker for 9 years, and we see you on a quarterly basis as required by OARs. We always give you an exciting update on the things that Charisma's been doing with her family and in her community outings.
I object. Is there a question?
Goodness, but instead of giving any testimony or prompting the question, if you could.
Oh, okay. Susie, do you have any evidence where you have documented in your case notes that you did a reconciliation of receipts associated with Charisma's mileage benefit as required in her current plan?
That's not my position. That's a management analyst. I don't do that piece.
Oh, okay. Someone missed that piece, because it would have been that opportunity for anybody to express any concerns that they had with us about our mileage usage. There would have been 2 of these that would have happened in the time period from when the mileage started. So, okay. Susie, there was data in Charisma's K plan that you prepared for us and asked us to sign that day. That was very false, totally untrue, and I told you that I could not sign the document for that reason.
So are you referring to a specific exhibit?
Yes.
What exhibit is that?
Yes. That would be, okay, where is it? C14, sorry. And that would also be the plan that I refused to sign is C19. So C19 is the K plan that I refused to sign because of utterly false information that was included in that plan. When I asked you, Susie, where you got that data that was no longer true about Charisma, what did you tell me?
I told you that I got it from our BSP. I did a
And what is the date on that behavioral support plan, Susie?
But that wasn't the only document.
But just answer the question. What was the date on the BSP that you drew language from and put it in the plan that you expected me to sign?
Well, the original BSP was 2005, and I believe there was an update in 2008.
Thank you. Let's see. I still have more questions.
Okay, I want to jump in. Ms. Larson, when you say BSP, could you, what is the BSP?
It is a behavior support plan. It's the document that people that work with Charisma use to support her in managing her behavior and to keep herself safe and keep others around her safe.
Okay, thank you.
Sure.
And Susie, when I told you that those statements were totally false, why did you not immediately say, wow, I got this wrong, I need to call in my supervisor, let's set a meeting where we can get this data correct? Did you ever once offer to change the untrue statements?
No, I guess I didn't realize it was, no, I did not.
I could not sign that plan. As Charisma's legal guardian, I cannot sign a document where untrue facts remain in that document. Susie, on February 25, Exhibit C20, I sent you a very detailed email the following day where I formally, in writing, informed you that those statements were utterly false about Charisma, that she's happiest in her bedroom and doesn't like to be out in the community for long periods of time. I specifically asked you to remove those sections, and I even went so far as to offer you current factual data that reflected my daughter's preferences and level of functioning. Did you, at any time, contact me and discuss those changes?
Well, I think you and I have talked about it, but no, I did not offer to rewrite her ISP or her annual plan because we started into this process and,
I'm not talking about rewriting the entire plan, Susie. I was asking you specifically. There were 2 sentences that you pointed to and even went so far as to underline, to emphasize to us on evidence C-19.
You underlined those. I didn't, and you made check marks. That was your writing, not mine.
Susie, I did not, and I have a witness that shows that. Susie underlined drawn-out activities in the community to emphasize.
I object. She's providing testimony. She needs to be asking a question of my witness.
That's fine.
Did you have a question about C-20?
About C-19, or, no, well, C-20, she answered the question. I sent her an email asking her to remove the false statements in writing, giving her options she could choose from, and she said no, she did not.
Do you have any further questions for Ms. Larson?
Yes, I do. Susie, how many notice of planned action documents did you send me?
2.
I have 3 here, Your Honor.
Is
that testimony?
Yeah, just waiting.
Okay. In your cover letter, Exhibit C-17, dated February 27th, that did accompany your first notice of planned action, in the first paragraph you wrote, as we spoke at our meeting on February 24th, your mileage is being reduced from $779 to $369 because mileage was being charged for family outings rather than activities that are particular to your preference and service needs. Susie, what beyond hello or goodbye to Charisma have you or anyone at Marion County ever said to Charisma?
I've had lots of discussions with Charisma. I used to go out to her foster home almost every single month and have discussions with her.
Okay, then how can you state on February 27th in your letter that your preferences overrode hers and her legal guardian in order to reduce the mileage benefit? Okay, have you ever had a conversation with Charisma about her preferences?
Which question do you want me to answer?
Pardon?
You asked me 2 questions. Can you ask me the first one again, and then I'll answer it? I don't recall what
I'm just asking, have you ever had a conversation with Charisma to determine her preferences in order to determine that her legal representatives were taking her on a family outing rather than activity that was particular to her preferences?
No, I have not had that discussion with Charisma.
Okay. Have you, Susie, or anyone at Marion County ever asked me to go along on a single outing with Charisma and I to any...
Your Honor, irrelevant.
It's not at all. To determine whether Charisma's preferences were being met.
That's not part of my job. I don't have the ability to go on outings with the individuals on my caseload, although that would be wonderful. I have seen you guys in the community, though.
But no one ever checked with me. Isn't it correct, Susie, that no one ever asked me regarding a single concern in any of your case notes about any misuse of funds? No one ever contacted me. Is that correct?
Our first discussion was at the ISP meeting.
Right. And no one ever went along on an outing. If someone had concerns, I would think that you'd want to go on an outing, even if it wasn't a part of your job description, before you made certain assumptions that are in your own handwriting in your case notes.
That's testimony.
You know, I did a very thorough file review, and so this is an accumulation of observations, discussion with providers over the years, my observations, you know, in the community and our meetings. So it wasn't just a single document that I looked at or a single experience.
And Susie, tell me, how do you think Gary and I determine Charisma's preferences?
I would assume by her level of participation, or maybe if she has behaviors on a particular outing that might indicate that she's frustrated or uncomfortable.
Is that all that you think that we use to determine whether she is on an outing that is her preference or not?
Well, I'm going to jump in here.
Okay.
Ms. Larson, do you have any personal knowledge of what the Kuhns based their determination of Charisma's preferences?
No, I would just assume because they're family members and they live with her, they would be able to determine what she enjoys and what she doesn't enjoy.
Okay, I think what you're asking, Ms. Kuhn, you're asking for the witness to kind of speculate on your and Mr. Kuhn's frame of mind, so I'm not going to allow that question.
Okay. Susie, in Exhibit C15B, in Charisma's most recent assessment, you determined that Charisma qualified for a full assist with communication, expressive, and receptive. And you even went so far as to include a special note in that section that reads, needs considerable assistance to express wants and needs. Family can read body language and understand limited verbalizations.
Yes.
Right? Yes. And so don't you, I mean, you stated in your own words that we can understand Charisma and her preferences and her wants and needs, but yet when you looked at the mileage log and you assumed certain things, you didn't come to me to ask how we determined where was an outing in question was her preference or not. Have you ever attempted to learn how to interpret Charisma's body language or limited verbalizations before you stated in your cover letter dated 2/27 that you knew Charisma's preferences better than Charisma herself or her legal guardians?
I wasn't, I don't think it was so much, you keep going back to preferences, but it's also about using the mileage with regard to doing family errands and I'm not sure how to answer your question. I'm not sure what the question is.
The only reason I use the word preference is that's the word that you put in your cover letter, and it's a very important word.
Would you do me the favor of repeating your question, please?
Susie, did you ever once make a single attempt to learn how to interpret Charisma's body language or limited verbalizations before you stated in your cover letter dated 2/27 that you knew Charisma's preferences better than Charisma herself or her legal guardians?
Over the years, I've attempted, of course, to get to know Charisma and understand what she's saying and what her body language is demonstrating. Yes, I've tried that.
Okay. Susie, on your first notice of planned action, which is Exhibit C17, and it's dated 2/25, you don't mention a single word about Charisma being happiest in her bedroom and not liking long, drawn-out activities in the community, as you told us were the reasons on February 24th as to why Charisma's mileage benefit had been reduced by 53%. Where did those justifications go when you went to create a formal notice of planned action?
Those are just examples that I'm giving. They're not the reasons for the mileage reduction.
Okay. In Exhibit C17, B, let's see, it's B. You cited OAR 410-120-0006, which is an OAR related to medical eligibility standards. This appeared on your second notice of planned action and has absolutely nothing to do with the action or reason for action noted on that notice of planned action.
That's something that you want to talk about in your testimony.
Okay.
Okay, now.
Okay, so why was a second of notice of planned action needed? And that one was dated February 27th.
I don't recall there being 3, but I do know that that was my first time I've ever filled out a notification of planned action, and I simply made some errors in learning the process.
Okay. Okay. And why, Susan, okay, I don't think I have any further questions.
Ms. Bell, did you have any follow-up questions you wanted to ask Ms. Larson?
Did, Your Honor. Ms. Larson, did you send an amended notification of planned action on March 7th?
I'm looking in the exhibits. I'm not sure I recall the date, but I'm looking. Yes, March 7th.
For sending the amended?
sorry?
What was the reason you had to send it amended?
Because the dates on the first one were inaccurate. There was the 10-day period, 10 working day period that I was unaware of. I didn't know that piece.
And is the notification of planned action notice that the department's going to change someone's benefits?
Yes, it is.
Is that the only notice that you're required to give someone?
To my knowledge, in a verbal discussion.
And just a second. Do you know if there are reasons why someone cannot, are there rules around using in-home service support money for mileage? Do you know what those rules are specifically?
Well, I'm getting to know them better. There's a new expenditure guideline out that I've become familiar with.
Is that why you staff with Salem then, central office?
Yes.
I don't have any other questions, Your Honor.
So, Ms. Larson, the mileage that the department was given to the claimant, those were for in-home supports? Is that how the department classified them?
Yes.
If you could bear with me one moment, Ms. Larson, I'm reviewing my notes. Hey, Ms. Larson, I'm going to ask a few more questions. I don't believe you covered it in your testimony, and if we're going over something we already had, I apologize. But when did the claimants begin receiving mileage reimbursements?
I believe it was September 2013. First month.
And you first had some concerns in, was it July?
No.
No.
In January, I started doing a very heavy-duty file review in preparation for the adult needs assessment and the ISP meetings, and that's when it came to my attention, because usually I don't have access to the mileage sheets. Those go to a different staff person here at the office.
Okay. And why was the claimant receiving the mileage reimbursements originally?
They chose not to when we originally enrolled her in in-home comp. They chose to use the dollars for staffing rather than mileage.
Okay, those are the only questions I have for you, Ms. Larson. Ms. Bell, did you have any other questions?
No, Your Honor.
Ms. Kuhn, did you have any additional questions?
No.
Okay. Ms. Bell, did you want Ms. Larson to stay on the line?
Yes, please.
Okay. And who is your next witness, Ms. Bell?
Brian?
Ms.
Yes.
Forrest, can you hear me?
Yes.
Okay, could you please, I'm going to place you under oath, so if you could please raise your right hand.
Okay.
Under penalty of perjury, do you swear or affirm that the testimony you shall give in this matter shall be the truth?
Yes, I do.
Could you please state your full name and spell your last for the record?
Mariah Amber Forrest, and Forrest is spelled Forrest.
Okay, and Ms. Forrest, who are you employed by?
State of Oregon, Department of Human Services, Office of Developmental Disability Services.
And what is your position with DHS?
Program Analyst 3.
What are your job duties as an Analyst 3?
So they changed over the years. I originally provided technical assistance to community developmental disability programs and employment providers. I recently developed and implemented a funding review process for high-cost items and services, and I'm currently developing and writing administrative rules, along with other duties as assigned, such as this hearing.
And Ms. Forrest, are you familiar with Charisma Kuhn's case?
Only with what I'm reviewing for the hearing. I listened on the pre-conference, and I viewed the exhibits.
Okay. You can please proceed with your questions, Ms. Bell. Ms. Bell, can you hear me?
I'm sorry. In your job duties as a program analyst, did you review exhibits A9 through A15?
Yes, I did. Heather, if I can say this, I don't know if you had asked for some other questions previous to that, and I don't know if you wanted to skip them.
If you could just, did you review exhibits A9 through A15?
Yes.
Why did some of the mileage violate DHS policy?
The mileage in question is not a cost necessarily incurred to implement President Kuhn's in-home support ISP plan for the standards and procedures in Exhibit A17, specifically Roman numeral 3, capital B, on page 3 of 4.
And what is DHS's policy on community transportation mileage?
As for Exhibit A18, page 19, trips must be related to, and I'll quote this, trips must be related to recipient service plan needs and goals, are not for the benefit of others in the household, and are provided in the most cost-effective manner that will meet the needs specified on the plan. Community transportation services are not used to, 1, replace voluntary natural supports, volunteer transportation, and other transportation services available to the individual, end quote.
And can you explain what Exhibit A18 is?
Exhibit A18 is guidelines, they're called expenditure guidelines, for expenditures which may or may not be authorized on the individual service plan for the state Medicaid K-plan services. Do I need to say what that is? I guess I just will. The Medicaid State Plan Amendment, which is authorized under Section 1915K, parentheses K, of the Social Security Act, is called the K-Plan.
Why is it relevant to transportation mileage?
Community transportation mileage may be authorized according to the guidelines in that exhibit, 18.
And what other DHS rules were applied to Ms. Kuhn's case?
There's Oregon Administrative Rules 411-330-0060. Some of the transportation mileage claimed for Ms. Kuhn is in violation of Oregon Administrative Rules. And specifically the subsections in that 6, small c, and capital E, that section regarding the mileage for prescriptions, because medical expenses are not allowed. In capital F, regarding mileage for food purchases. For example, a trip to Life Source was one thing I remember, because ordinary costs and for special diets, that kind of thing, not included. And capital letter I, regarding mileage for vacations, because those are excluded. And M, regarding mileage for travel not necessary for supports of social benefits, defined in OAR 411-330-0020. And I'll say under that definition, transportation is available access to community activities when no other option is available, such as family or other transportation services. It appears family transportation services would be available to Ms. Kuhn without state or federal funding, and it appears mileage was claimed for activities necessary for all people with or without disabilities.
And I'd just like to follow up on question specifically. If
Ms. Dawn, before you continue, I apologize for interrupting, but Charisma and her father had just left the room. But Ms. Kuhn's fine to continue if you are.
Okay. Under that rule, even if it is Ms. Kuhn's preference to go to pick up prescriptions, for example, is that allowed by rule then?
No, it would need to be tied into an ISP, and because some things are preference, if a family's going on just going anywhere out of the house, it doesn't mean it's an appropriate claim for a transportation service through an ISP, even though it may be her preference to do so, because that is a customary activity of people, of all people.
Would you like to elaborate on transporting other family members?
If travel is for a family trip or for family activity, usually all the family is included, so that mileage would not normally be incurred. If it was a specific ISP goal, something that she had planned to do, and it was for her, then other people could be riding with her. But she does have to be in the car when mileage is claimed, and I'm not sure if I went in the right direction with what you were asking.
I actually have an example of one. Would transporting her to take her sick aunt's soup be something that we could reimburse for?
I would say generally no, because that wouldn't be an ISP plan. You can't say blanket no ever, never, but because if there was a specific goal to family participation or something that was that might fall under. But I would say generally looking at that, it would not appear to be appropriate expense. It would be something probably that the family would be doing for the aunt anyway, and not be because of her. Because really it's for accessing services for the plan. We provide transportation as an ancillary service so that people can do their plan, so they have access to it, so that the transportation doesn't prevent them from being able to accomplish what is in their ISP. So I don't think, if you look at it that way, that would probably happen anyway. One would hope that someone would be helping out a family member. So I don't see that would normally be something that would be claimed as mileage.
And how about picking up wedding pictures for her sister?
That would be probably the same kind of thing, unless she had particular interest in photography and was doing something with them, or it was to make a collage of pictures or something that was part of her ISP plan. Then that could possibly be appropriate, but just on face value, it may not be, depending who derived the benefit from it and what was the purpose of it. So if the benefit was to have the pictures to give to the sister because she's making her wedding album, then that would be no. That would be totally inappropriate. If it was for Christmas to make a collage or something, as I said, then that may be.
And is there anything you would like to add?
Yes. A couple things. The mileage was inappropriately claimed for September 1st and 2nd after reviewing, specifically looking through the file. The signature date of the ISP was September 3rd, 2013, and per OER 411-330-0050, Section 3, quote, prior to services beginning, the ISP must be signed by the individual or the individual's legal or designated representative as applicable, unquote. So that's just one point, but that's it's something I noticed in that. And I would like to say that all supports provided have always been meant to be based on support needs. We probably didn't, as a system, didn't have as good of assessment as was necessary, though we have implemented an assessment, which is what Susan Larson referred to, that's being done for every person, and that's receiving in-home comprehensive services. And so this assessment bases their needs on the supports that are necessary. So it is appropriate at this time with everyone in our system that the services provided be directly tied to their needs. So I just wanted to say that as part of our process. So what Susie was referring to is happening for everyone within our system over this from July 2013 onward. Forward.
I just had one question that I wanted to get in at the beginning and missed. What's your training and education that allows you to be a program analyst?
I have a Master of Human Services Administration degree and over 30 years of experience in social services programs, including direct service and management. I'm a certified rehabilitation counselor, and I hold an Oregon Procurement Basic Certification.
And that's all my questions. Thank you.
You're welcome.
Ms. Kuhn, do you have some questions for Ms. Forrest?
I do. I'd like to ask Heather one question regarding a question that she asked.
Heather's not going to testify, but you can ask me what.
Oh, well, it wouldn't be anything you could answer, but I'll go ahead and skip that part. But I do have a question.
Mariah,
I do have a question. I'd like clarification on the two examples that Heather presented to you. When taking the soup to the aunt and determining whether that was a transportation benefit that should be allowed, wouldn't it be important to contact the family to ask more details before a determination was made about such a entry on a mileage log?
If it's in question, yes.
Okay, and if that delivery of soup to a sick aunt involved a structured learning activity for Charisma, where she helped me write a shopping list, went to the grocery store and actually pushed the cart, put the vegetables in the cart. We talked about naming the vegetables, the colors that they were, and we brought them home, and she chopped, and she cooked, and she stirred like she likes to do, and she scooped, and we had verbal discussion about what we were doing and who we were going to go see. And then we jumped in the car and we took the soup to Aunt Millie, who is the only individual in Charisma's life, the only other individual in Charisma's life in a wheelchair, where she participated in a physical therapy session with the professional that was there that day. In your opinion, would that qualify then for mileage reimbursement?
Not necessarily. It's not tied, and I think that probably is a question that's more appropriate for the services coordinator. However, I would say that it would need to be tied to an ISP and a goal, and I think it being a normal everyday activity, I would hope that, especially if you're the paid provider, that you would be doing the skills training throughout the time that you're working with her and taking her to the grocery store and that type of thing. So I don't see, and then the family would have to get the groceries and the things for the aunt, so the purchase isn't really for Charisma. I think, so it doesn't really seem that it would be. And then if you're talking about a medical appointment, therapy, I'm not sure if you said, I think you said physical therapy, any therapy appointment would be a medical transportation expense, which we do not cover.
Oh, that was just an activity that she happened to be present and participated with her great aunt. It is tied to our ISP. Shopping and daily outings in the community is a part of Charisma's ISP. And so is money management, the
Providing testimony.
Oh, okay. And then let me just clarify the wedding pictures, which I have already clarified with Heather in a recorded phone conversation where I explained to her that...
Oh, did you have a question?
Yes, I was going to say, if the pictures that Charisma picked up at Walgreens were pictures that she was in, that she was bringing home, and we were working on addressing the envelope. It was a structured learning experience, and Charisma was deciding and had a little list of people that she was going to mail those pictures to of the proud day where she attended her sister's wedding. And then we got in the car and went to the post office to buy the stamps to put those wedding pictures of Charisma with her sister. We did not pick up pictures for a wedding album for her sister. But these were specific pictures with Charisma in them that she was sending to family and friends. Would that be allowed?
I think that, generally speaking, it's possible if it's tied to an ISP. I think when I review the mileage law, I would like to, part of it, because it's part of the entire picture, is that the mileage logs show almost daily going somewhere, and I don't know that all of those are necessarily tied to an ISP plan, especially when I didn't see very much described in the goals of an ISP.
Do you have any other questions? Ms. Forrest, I have a few questions for you myself.
Okay.
The mileage reimbursements in this case, are the payments of these mileage reimbursements, do they fall within Division 330 of the administrative rules?
Yes.
And is Division 340 applicable at all?
It is not. And I could explain that further if you need.
Yes, that would be great. Thank you.
So Division 340 is in DD services. It has been a pretty bifurcated system. We have services that we call comprehensive services. We're under the comprehensive waiver up until July 1st, and we have support services, which are under the support services waiver up until July 1st. So the systems are very different. Services under the comprehensive side of the system were under a case manager called a services coordinator at the counties or community developmental disability programs, and the services under support services were provided under a case manager called a personal agent through a brokerage system, and they were always in the person's home. So the services were very different, and they've somewhat merged with this K plan that's come into effect July 1st, but the services have not changed for people, so they're still operating through the same systems, essentially. There's lots of changes, but in terms of individuals, they should not really be seeing changes that are, provided that the services are appropriate and according to rules and policies. So that the 340 rules are for the support services, and that's not the services that Charisma has been receiving.
Thank you for that.
Yeah.
If you could hold for one moment, Ms. Forrest.
Sure.
Okay, I don't have any further questions for you. Ms. Bell, did you have any further questions for Ms. Forrest? Ms. Bell?
No, Your Honor.
Okay. And does the department have any additional witnesses?
No, Your Honor.
And Ms. Bell, would you like to take a break now before we begin with the claimant's case?
Yes, Your Honor, that would be good.
Okay, it's now 10:20. We'll take a 15-minute break and resume at 10:35.
Okay.
Thank you.
Okay, I'm gonna leave the teleconference open. You're free to either get off the line and rejoin us, or you can stay on the line. But everything is being recorded at the moment, so I'll let everyone know that.
Thank you.
All right, thank you. The time is now 10:35. Do I have Heather Bell on the line?
Yes, Your Honor.
And do I have Ms. Boris on the line? Ms. Larson, are you still there?
I am here.
And Ms. Forrest, are you there?
I'm here.
Okay, thank you. We'll go ahead and resume the hearing.
Yes.
Ms. Kuhn, who would you like your first witness to be this morning?
Can I call my husband?
Sure.
Okay, that would be Gary.
And Mr. Kuhn, if you could please raise your right hand. Under penalty of perjury, do you swear or affirm that the testimony you shall give in this matter shall be the truth?
I do.
Okay, and for the record, would you please state your full name and spell your last?
It's Gary, last name Kuhn.
Okay, you can proceed, Ms. Kuhn.
How do you remember Susan Larson? What do you remember Susan Larson stating on February 24th, 2014 at the K-Plan signing meeting where she presented her first rationale as to why the miles had been reduced from 779 to 360 miles a month?
The first rationale that I recall, and I can quote almost verbatim, is that you were using too many miles, logging too many miles, to visit family.
I understand you had a telephone conversation with Mike Parr, Support Services Coordinator surrounding community. How did Mike Parr define community to you during that conversation?
Mike's definition of community was that it depended on where an individual lived. So a person living in one area of the state, their community might be considerably different than a person in another area of the state. He gave an example, someone living in Eastern Oregon, where there weren't other kinds of things. That person could travel to another community to partake of those kinds of things. And so when we spoke about those types of things specifically, he said that if there were a Macy's store in your town and you went to a Macy's store, if you went to Macy's in Portland, that would not be your community store. But if you went to other things that were not available in your community, that could be considered the larger community.
Thank you. How did Heather Bell define community during the conference call on March 20th?
And I can quote that verbatim. Community is just that, community.
How did Susie Larson attempt to define community after conferring with a state employee and sharing with you the definition of community?
It was a little bit confusing to me, but it basically was saying community is local community, and that was vague, and that's why I went to Mike Parr.
Are you aware of any attempts by Heather Bell to have you discontinue your conversations or email interactions with Mike Parr prior to today's hearings?
Yes, I asked an additional set of questions as Mike Parr was being quite helpful. Emailed him a set of questions. I don't remember the exact number, but 6 or 8 questions trying to get clarification on some of the confusion that we had. Shortly following that, you received an email indicating that if we had questions, we should direct them to Heather Bell in the present. If there were questions in the future that did not regard this hearing, you could direct them to Mike Parr.
Please describe for me how you see Charisma benefiting by being out in the community, shopping, attending farmers markets, etc.
Being that I'm on most of those outings, she benefits in multiple ways. One, for example, you mentioned farmers market. She gets an opportunity to see and smell and be experientially involved in different kinds of shopping experiences. She gets an interactive opportunity to socialize with vendors, with musicians, with other individuals like that. She gets to use money management skills by purchasing whatever it might be, cauliflower, cocoa, whatever that might be, that is something that she wishes to purchase as a food item. In other contexts, the zoo or other kinds of places, she gets to enjoy and have a normal life and have what other people might have. So she seems to enjoy it. It seems to benefit her. It seems to give her opportunities, and she gets to interact with other people that if she were to be at home, she would not get to interact with the larger world.
And the benefits of her shopping and money management and socializing, are those a part of her ISP?
Yes, the ISP that I've read that she is currently on, those are benefits to her that she can partake of and are encouraged in an ISP.
When has Charisma ever availed herself of any transportation where she is not accompanied by a guardian, family member, or paid support worker?
In her lifetime, the only time would be on a school bus where there was a bus driver that was transporting her. So that was a paid individual. It wasn't necessarily a paid support worker. Otherwise, she has never ridden a bus by herself. She has not been in a taxi cab by herself, a shuttle for people with disabilities, or in any other kinds of transportation because of her disabilities.
And is that because she didn't want to go on a bus or a taxi, or we didn't want to put her on a bus or a taxi, or why are those other options not available to her as other forms of transportation?
Her behavior and her ability to be mobile and ambulatory restrict anyone that is not trained to be with her, put her into a public setting, including being on a bus with someone that might be near her or in front of her or around her.
And does she need, what level of support does she need with transportation?
Full support is what she needs because she needs to be put into the vehicle. For example, if I'm driving, I need to seat her, seatbelt her, take her wheelchair that she's been transported to the vehicle, put that into the car, and then on the reverse of that, the same thing, unbelt her, get her, and allow her to be out of the car into that wheelchair, and then transport it to whatever location we're at.
Can she make any of those arrangements for any other form of transportation herself?
No, she cannot.
And is there any official documents that Charisma needs, full support, or is it called full assist in the transportation category of her life?
There is in a recent assessment that was conducted in January, there is a checkbox, and in that checkbox it does say full assist, and I can't quote it, but it's in the evidence, something that I read that said she needs full assist, cannot provide any assistance by herself.
And is Charisma safe in the community when she's not attended by someone who knows her well?
Can you define safe?
Could someone hurt her, or could she hurt someone else?
If she were by herself, she could easily be hurt by another individual if they had ill intent. She could hurt herself because her ambulation is limited, and so she could fall and hurt herself, and she can't manage any aspect of her life in regards to being aware of others around her, their intent, or making any decisions on her own.
Okay. And the last question, did you feel pressured at all to sign the K plan on February 24th when Susan Larson said, if you don't sign it today, the plan will begin tomorrow?
I did feel pressured in as much as that we wanted that plan to go into effect because of the increase in the personal care from 16 hours at current to 19.6, and it seemed that she was encouraging me to put my signature on there, or if I did not put my signature on that day, that increase would not go into effect immediately, and that would be a financial loss. So it almost appeared to me I was buying a used car when she said that. I felt pressure to sign before walking out the door.
And why didn't you sign? And that'll be my last question.
The reason I did not sign the plan was for two reasons. One, the reduction in miles was not explained to my benefit. It was explained that we were visiting family and using miles to visit family, and then the false statements about our daughter's current state of behavior and such that is no longer current. That does not depict her accurately, as much as that she loves getting out of the community. She loves Disneyland. I take her there twice a year. She loves concerts, and I would take her to every concert possible if I had the ability to do that, ones that she loves, and it's just a simple matter that that's her life.
No further questions.
Ms. Bell, did you have any questions for Mr. Kuhn? Ms. Bell?
No, Your Honor, I don't have any questions.
Okay, thank you. Everyone could bear with me for one moment. Mr. Kuhn, you stated that you disagreed with some of the statements in the February 24th assessment. Could you, I believe the assessment you're referring to is Exhibit A18.
RC19, is that okay?
That's in the C19, Your Honor, annual support plan.
Yes.
Yes.
So
Yes.
specifically, what statements did you disagree with?
Okay.
Well, you know what? I'm sorry. I think we're looking at different documents here. So I was looking at the wrong document. Okay, I'm looking at C19 now.
Okay.
That's the annual support plan. So could you identify what statements you disagreed with?
I certainly can. The section that says about on page C19, under home, schools, supported employment, pre-vocational, alternative to employment, habilitation, and caregivers, includes individual strengths, interests, likes, and dislikes. The first statement states Charisma is happiest when she is in her bedroom, swinging and listening to music or watching a movie. My reason to disagree with that is that she enjoys being in her room, swinging and listening to music. She is happiest in many other places, and the use of the word happiest to me indicates that one cannot be happier, and that is not where she is happiest.
Is there anything else?
The other statement that I disagree with is where she states in the record on the annual support plan further down, she enjoys being in the community for short periods of time, but does not like loud noises, crowds, or long, drawn-out activities in the community. The reason that I disagree with that and have an issue is that she loves being out in the community. She loves going to farmers markets and enjoys being at activities, concerts, other kinds of activities that take place in the community. And the statement that follows that is contradictory to that, which there shouldn't be a contradictory statement in an annual support plan, which says she enjoys concerts and trips to Disneyland. And so that statement that follows that, I totally disagree with the drawn-out activities in the community, since I do take her to Disneyland, and that is not a place with you're there for 12 hours a day. Those were the statements I was referring to, Your Honor.
And has a brother?
She does.
He lives out of town?
He currently has been a seasonal worker, and so he goes different places with Fish and Wildlife. He was in Corvallis at one point in December of 2013. He was in Port Orford. Following that, he was in another part of Washington. He's now in another part of Washington.
And I believe in your mileage logs, you identified some trips that you took to see. This is your son?
Correct. It's our son, yes.
And who went on those trips?
Charisma's brother, my wife and I, and Charisma went on that. It was actually, the trip I think in question is to Port Orford, unless there are other ones noted there, would be that trip, my wife, myself, and Charisma.
Okay, let me try to identify the specific date here.
It would have been Christmas Day, and the day following Christmas Day, the 26th, would be the return trip from visiting him for Christmas.
Okay. Looks like in November, he was in Corvallis.
Correct. That's when he was in Corvallis.
And was there a specific reason on, let's start with November 1st, 2013. Was there a specific reason why Charisma went to visit her brother?
I'm not looking at that myself. I can,
What date are you looking at?
so I'm looking at the same one. December 1st?
Should be November.
Oh, okay, November 1st. In the log, and I was not that, I believe that was a weekday. I was not with Renee and Chrisma that day, so the only thing I can address is what's in the log. I can't address what actually happened.
Okay.
And what my wife told me, but I was not there.
Then you drive your own vehicle when you're, for these trips with Charisma?
For the most part, I'm trying to think if that particular trip we were in our own vehicle. Yeah. Trying to think when we have rented vehicles before, but on that trip, we were in our personal vehicle. And all of the trips that are noted, generally when I rent a vehicle, it's because either a car is missing or my wife and I, without Charisma, are going on a trip. So for those, they would involve in a personal vehicle, yes.
Okay, Ms. Kuhn, did you have any further questions for your husband?
No, I don't.
And Ms. Bell, did you have any further questions?
No, Your Honor.
Okay, Ms. Kuhn, who would you like to testify next?
My testimony.
Okay.
Okay, I don't have anybody else.
Okay, if you could please raise your right hand.
Okay.
Under penalty of perjury, do you swear or affirm that the testimony you shall give in this matter shall be the truth?
Yes, I do.
And for the record, would you please state your name and spell your last?
Renee Kuhn, Kuhn.
Okay, Ms. Kuhn, please proceed with your testimony.
Okay, thank you so much. Your Honor, we are here today to contest an attempt to Christmas mileage benefit on February 24th, 2014 in a yet-to-be-signed communique plan. I will be referencing two different plans regarding Christmas support services throughout my testimony. The first is Christmas' current 24-hour in-home comprehensive services plan that I will refer to as her ISP. And the second is her new proposed ISP that I will refer to as her K plan.
Okay, I'm sorry to interrupt, but
Okay.
the ISP, the first one you referred to, is that in the exhibits?
Yes, it sure is. And that one, the C18, A through C, A through D, actually.
C18.
Yes, that's the one that she currently is supported under.
And you said there was a new plan?
And then the one that we refused to sign on February 24th, called the K plan, is Exhibit C19.
Okay.
Welcome. To help you get a quick understanding of the differences between these plans, it is important that I briefly describe them for you. Christmas' current 24-hour in-home comprehensive services plan, her ISP, provides her with 16 hours of support each day to assist her in her activities of daily living in her home and in the community. 16 hours is the maximum number of hours allowed under this program. Christmas family is required to donate 8 hours of support each day to cover the full 24-hour period in a day. Currently, I provide the majority of Christmas paid care, but have 2 support staff whose hours vary month to month based on the time of year and our family's need for relief in meeting Christmas complex medical and behavioral needs. In the summer of 2013, I requested that Christmas be reassessed because her level of functioning had decreased and the level of medical need had increased. That assessment indeed proved that Christmas needs were higher, and therefore her annual support plan dollars were increased to provide for 19.6 hours of paid caregiving support in a day in her new K plan instead of the previous 16. Last year, I discovered an error in Christmas' previous ISP and brought that error to Susan Larson's attention as documented in Exhibit C13 in her case notes. Susan Larson has been Christmas case manager for approximately 9 years. Correcting that error resulted in additional funds being available in Christmas' plan. In Exhibit C21, Susan Larson, in an email to me, asked if we wanted a mileage benefit in order to use those funds, and asked how many miles we would like should she be able to get that benefit approved for Christmas. A mileage benefit was approved for Charisma, and Marion County determined that she was eligible to receive 779 miles a month, a benefit we never asked for, but we're happy to accept. Exhibit C25. Second. Okay, Exhibit C25 is our list of which you didn't want to include because it was a duplicate from their package, are the mileage logs, which will document for you that Charisma's mileage benefit did indeed begin on September 1st, 2013. But before I go into the majority of my testimony on it, I would like to start with just a short segment to help you get to know Charisma a little bit better and the family that supports her, because some of Marion County's documents contain gross errors in the description of her level of need and functioning that I will prove here today. These false statements are the reason I refused to sign Charisma's pay plan on February 24th, where the surprise mileage reduction had taken place. The facts that I will now share with you about Charisma will be the basis for helping you to determine whether certain allowances pertain to her transportation benefit or not. Every plan and every assessment done about Charisma to date clearly states the importance of her maintaining a strong family relationship with her family, as absolutely vital to the quality of her life, as documented in the first sentence on the first paragraph of the first page of Charisma's current ISP in Exhibit C18. And it reads, purpose of plan activities: independence, integration, productivity, development, and maintaining the capacity of the family. Due to Charisma's developmental and physical disabilities and dangerous behaviors, she requires constant care and monitoring for her health, well-being, and safety, and for the health, well-being, and safety of those around her. Support from this plan will enable Charisma to preserve her independence as much as possible, as well as maintain the capacity of the family to continue to care for her in the family home. Charisma has always had a strong family connection with immediate as well as extended family members, as numerous mileage logs clearly document. All of Charisma's immediate and extended family live outside the Salem area, except for her father and I. To visit other family, Charisma must travel outside of the Salem area. Family members look forward to visiting with Charisma frequently and send her cards and gifts on holidays and her birthday. Charisma's quality of life, her personal health, and her inner joy would be significantly diminished without her family playing a vital role and advocating strongly for her in all areas of her life. You cannot talk about Charisma without talking about the family that supports and loves her. Our family has incredibly remained intact against insurmountable odds, which has benefited Charisma and her quality of life beyond words. As her legal guardians and biological parents, my husband and I work hard each and every day to help our special daughter feel loved, safe, and important, and an integral part of her immediate family, extended family, and her community in order to live the highest quality of life possible. A marked difference between other disabled individuals with the same level of disability as Charisma who do not live in their family home. The following facts about Charisma are the reasons why she was determined to be eligible for 24-hour support. Charisma has both Down syndrome and autism. She's incontinent. Her IQ is 36. She's basically nonverbal but speaks rarely, or when assisted to speak, via a specialized communication technique we discovered when she was 2 years old. Her receptive language is much more developed than her expressive, which means she understands much more than she can express, and this has been a factor throughout her entire life. Charisma will turn 32 this month. Her current ISP documents significant support funds via hourly care due to a lifelong serious sleep disorder where she gets up frequently in the middle of the night and does not go back to sleep, needing one-on-one support. Charisma has a serious aggression problem where she can hurt others and destroy property, and so in 2005 a behavioral support plan was created. Charisma is dependent on others 24 hours a day in all aspects of daily living activities. She cannot even get herself a drink of water, and so Marion County has a dehydration protocol included in her ISP. She has an aspiration protocol because of the risk of choking, as well as a constipation protocol. Charisma is literally dependent on others to keep her alive every day. She has never once in 32 years ever brushed her own teeth. However, she's never had a single cavity. Charisma cannot bathe, dress, or undress herself. She cannot use the toilet independently or wipe her own bottom. She cannot prepare her own meals, shop for food, order, pick up, or administer her own medications, or even entertain herself with free time activities for more than a few minutes. She cannot do her own laundry or make her bed. She cannot drive, open a car door, or buckle herself up. Activities that Charisma is unable to participate in are: she cannot roller skate, ice skate, ride a bike, go bowling, swimming in a public pool because of bowel incontinence, library because of her verbal sounds, which can be incessant and loud much of the time, be outside when the weather is cold because she will not leave a hat or gloves on, or outside when it is very hot because of her heat sensitivities. Charisma is unable to maintain friendships due to social and behavioral and nonverbal disabilities. She is unable to initiate, build, or maintain friendships. She has no desire to reach out to anyone via telephone, email, or any other kind of communication methodology. Charisma's family and her caregivers provide nearly 100% of her social interaction. She is incapable of independently taking any form of public transportation and needs full assistance to access her family and the community. She has to be accompanied by a trained caregiver whenever she's out in public. Marion County requires that Charisma have someone who can either see or hear her at all times. Charisma's family consists of her biological parents and a biological younger sister, Cammie, who was diagnosed with kidney cancer at age 3.5, and a younger brother who's 26, Corey. When Charisma is at home or in another state on a trip, she requires the same level of support in all settings. I will now go into the violations on the part of Marion County. Violation 1, the Exhibit 2. And that is, the first violation of note is the fact that Susan Larson violated OAR 320-0060, shown in Exhibit 2, that clearly states the right to prior notice of any action that terminates, suspends, reduces, or denies service, and notification of other sources for necessary continued services. In OAR 411, 330-0130, it states here that the CDDP must mail the notice or personally serve the notice to the individual, or as applicable, the individual's legal representative, 10 days or more prior to the effective date of the action. Susan Larson confirms, Susan Larson did not notify me in any way that she was even considering reducing Charisma's mileage benefit, or that a final decision had already been made to place that reduction into Charisma's new case plan until she presented the case plan to me on February 26th. Susan Larson herself confirmed in her case on 1/6 Exhibit C13C. That no prior notification was given when she states in the last sentence, I will put the 360 miles per month in her ISP and explain this change to the family at the ISP meeting. Susan Larson never provided Charisma with prior notification when she blindsided us on February 24th with a significant 53% mileage reduction that she had already put into an official document that she expected us to sign. Needless to say, that meeting did not go well. In preparation for creating Charisma's new case plan, Susan contacted me by phone and by email a few times since January 6th, asking for our input for data into Charisma's new case plan, but never once did she reference the mileage reduction or that she had a single concern or issue about our mileage usage. The email I'm referencing is Exhibit C21. Dated January 31st, and I will read. Good morning, Renee. A few questions. First of all, I need to document in KK's annual plan some things that are working well for her and some things that are not working well for her. Additionally, some goals for the upcoming year. From my perspective, living with her family is definitely working, so I already put that in the plan. I think we could come up with some goals around increasing her independence in the home, more cooking. I know you do those kinds of projects with her, so I'm sure there's something we can simply enhance as a goal. And the remainder paragraph in that email just talks about the 24-hour care and our respite needs. January 31st, no mention of any decision or any concerns with our mileage usage, no decisions, even though on January 6th, she already made the decision, said she would tell us at the ISP. Back to Exhibit C13. In that same case notes on January 6th, and I will read. In preparation of Christmas ISP later this month, I reviewed her file again. I noted that some of the mileage was being billed for appears to include running errands and going on family trips that don't appear to be for Christmas benefit. I sat down with my supervisor, Dawn-Alisa, and we reviewed them together. We agreed that some of these expenses may not be allowable under IHCC. We reviewed the sheets closely and came up with an average of miles that were used for activities that would be for Christmas enjoyment, rather than necessary errands or family trips that would occur even if Christmas wasn't there. And it was at that point, Your Honor, that a comprehensive discussion had occurred, deep analysis of my mileage sheets had taken place, decisions were already made that we had done something wrong, and no one came to us on January 6th or any time soon thereafter to say, okay, you guys, let's get together. What did you do when you went here and there? And if we could justify what we did, help us state it in the way that it would be presented, that it should have been presented. If I didn't do it, there was no such conversation taking place. Contrary to what Susan Larson said, she had faxed me 3 notice of planned actions, all with a different date. And those are in my Exhibit C17. Susan Larson's first notice of planned action, C17, is dated February 25th, 7 weeks after she had already made the decision to reduce Christmas mileage benefit by 53% and place that reduction in an official document she expected me to sign on February 24th. At the very least, a notice of planned action should have been sent to her shortly after she made the decision to reduce the mileage benefit on January 6th. However, this notice of planned action was sent to me on February 27th, 3 days after I requested a hearing from Susie Larson on February 24th at the meeting where I refused to sign the K plan. I told Susie at that meeting that I wanted a hearing, that I would not sign that document that contained false statements about my daughter, and if they were not changed and corrected, I couldn't sign the document. It took 3 days before Susie Larson sent me my first notice of planned action, and only until I sent her an email telling her I would contact someone at the state level and ask them to help me with instructing me how to proceed towards the hearing if she could not. Within minutes, I received her first notice of planned action, dated 2/25. Accompanying that first notice of planned action was her cover letter, and that's where she brought up the issue of preferences. She stated there, addressed to Prisma, that we were logging miles inappropriately, I'm paraphrasing, and they had been reduced from 779 to 369, which was an error that she later corrected per my request. It was reduced to 360 because we were charging for family outings rather than activities that are particular to your preference needs. Okay. Violation number 2 is Exhibit C3. And that is OAR 411-330-0050, which states, an individual services coordinator must conduct and document reviews of an individual's ISP and resources with the individual, as applicable, the individual's legal or designated representative as follows. At least quarterly, review and reconcile receipts and records related to the purchases of supports with IHS funds. You will turn, Your Honor, to Exhibit C18, page A. You will see that there's a column where Susie said that it wasn't her responsibility to do this, so I don't know whose it was, but someone did not do this with us. She's required, or someone was required to do a monthly review of expenditures and a quarterly review of plan effectiveness. Okay? It was required in the transportation section that a quarterly review be done. That was never done with us. There were 2 quarters in the time that we were logging miles, and no one at Marion County ever came to us, even on January 6th when Susie documents in her case notes that she had concerns and decisions were already made to take away miles. No one ever came to us at that point or any other point when they were required by OARs to do a quarterly review with us, reconciling the mileage loss that was never done, where someone could have brought up some concerns, or to help us understand that we were doing something wrong. And January 6th was over 4 months since the mileage benefit began, and over a month past which she was to conduct a quarterly review of expenditures. Violation number 3 is Exhibit C4. The third violation involves Susan Larson using data from CRISMA's 2005 Behavioral Support Plan to create CRISMA's new K Plan in 2014. Susan stated to me on February 24th at the signing meeting that certain data from CRISMA's Behavioral Support Plan was used to justify the 53% reduction in CRISMA's mileage benefit. And I'm going to read that OAR right now. 411-320-0020-33, current documentation, means documentation relating to an individual's intellectual or developmental disability in regards to the individual's functioning within the last 3 years. Susie drew information and stated to me on February 24th that she drew from CRISMA's 2005 Behavioral Support Plan and included data which I told her was utterly false, and I couldn't sign it because of that. Later, on March 17th, I believe it was, Exhibit C14, the very last page, which is K, is where Susie Larson, per my request, faxed me a copy of the behavioral support that she told me she used on February 24th to create CRISMA's new K Plan. The details of the signing meeting on February 24th, I'm going to describe what happened. A meeting was set for us to come in and sign CRISMA's new K Plan on February 24th at Susie Larson's office. Minutes into the meeting, Susan Larson told us that CRISMA's mileage benefit had been reduced from 779 miles a month to 360 miles a month, a 53% reduction. I asked Susan why her miles had been reduced. We were stunned, literally stunned. And the first words out of Susie's mouth were, "You were logging too many miles to visit family." When I questioned her further as to why the mileage had been reduced, she directed my husband and I to the About section on Exhibit C19. And I will read that. CRISMA is happiest when she is in her bedroom swinging and listening to music or watching a movie. She likes to have an object in her hand to manipulate at all times. She sometimes sings with her mother and has helped prepare some meals in the family home. She enjoys being in the community for short periods of time, but does not like loud noises, crowds, or long, drawn-out activities in the community. She enjoys concerts and trips to Disneyland. She does not like spending time with people, as she prefers to be alone, and it takes her weeks to months to warm up to a new person. The hair on the back of my neck stood up when I read this data. And the reason that it was so powerful was Susie directed us to that section, and Susie herself underlined drawn-out activities in the community as justification as to why CRISMA's mileage benefit had been reduced by 53%. If it was simply an issue of somebody making a mistake, because we immediately reacted. I immediately told her, I can't sign this plan. I won't sign this plan. This is untrue about our daughter. If it was an issue of a simple mistake, any professional person would have said, Renee, we've got it wrong here. Let's do whatever we have to do to get this right. If we had to set another date, if she had to go get her supervisor, or whatever. Susie made no offer to correct the false statement about my daughter that she took from a 2005 behavioral support plan. The following day, I'm going to skip to Exhibit C14, and that is CRISMA's Behavioral Support Plan. And to my knowledge, it's never been updated. If it's been updated, when I asked Susie for a copy of her Behavioral Support Plan, she didn't send me the update. I would have been a part of that update. I don't know who would have done it without the legal guardian present. And even if it was updated in 2008, that was 6 years ago, well beyond OAR that requires documentation be no more than 3 years old. Okay, so this is C14, the very first page. This is the section that Susie Larson drew to put into a case plan in 2014, and it reads, Charisma likes swinging in her room, watching videos, especially ones with music, watching the morning shows on Channel 10, playing records, listening to music of all kinds, and on and on and on. Your Honor, if we go back to Exhibit C19, you will see that Susie Larson intentionally and willfully changed the wording from the original document that she was quoting and put it into a 2014 plan that she was told immediately did not accurately describe my daughter, when using that to justify a mileage reduction. There's no other way for me to understand why she didn't immediately retract that, except that, and I can hardly even speak it, but Susie wanted to give the impression that Charisma prefers being in her bedroom so she doesn't need the miles to go out in the community to access her family and her community. The following day, Exhibit C20 is a very detailed 4-page letter to Susan Larson, where I formally and in writing asked her to replace. I gave her the chance. I said, here's a paragraph that needs to be replaced about the about paragraph on the first page of Charisma's new plan. Please expand the field to accommodate all this information or whatever. I gave her tons of information, current, accurate, that Susie is very well aware of, because in that plan, where she included the outdated information, she made a mistake and included the truth, which was Charisma enjoys concerts and trips to Disneyland. You cannot have it both ways. Either one or the other. When Charisma's in Disneyland, she is out in amongst 40,000 to 50,000 people for 3 solid 12-hour days in a row. She doesn't get tired. She doesn't get cranky. She behaves perfectly. We have all the supports in place to make this a successful event. She goes on an airplane. She rides in a strange rental car. She sleeps in a strange bed. And, Your Honor, at this time, I want to ask permission to play my video evidence showing Charisma in her bedroom where Susie said she was happiest in 2014.
Before we begin that, Ms. Bell, do you have a copy of the is this a PowerPoint?
It's a
or a CD?
Unless it's Exhibit 28.
Yes, Exhibit 28.
It's on Exhibit 28.
Yeah.
I do have a copy then. Let me...
Okay, did you need a few minutes? Did you want to follow along, or?
I do, Your Honor.
Okay, so why don't you go ahead and put the DVD in and let me know when you're ready.
Heather, it's in 28B, the folder 28B inside of that CD when you open it. And it's the very first video in that folder.
Oh, okay, and it's 28B?
B. And there's 2 videos in that folder, and it's the very first one. You tell me when you're ready to go.
Okay. I just have the pre-hearing. Let me go to a different area.
When you open your CD, there should be 3 folders, and it's folder 28B.
And it's 28B, and it says Charisma in her room, MP4.
That's it.
Okay. For some reason, it's not opening for me.
It takes a while, Heather. It's a large file. We won't play the entire thing. It's an 8-minute video, but
Let me try one.
Is the video coming up at all for you?
No, Your Honor.
I'm not an expert on computer files by any means, but it appears this is a Mac.
Yeah, and we played it in other ones.
I don't know if the file type may be affecting, because I believe the state is on PCs, and I didn't try it myself beforehand.
I didn't realize there was multiple. The informal conference played, but that was it. So
That's in a different folder altogether, Heather. Maybe you want to take it out and insert it again and click on 28B. Don't open the other one.
okay. I don't have any picture. It's just sound. It's sort of.
Did you click on 28B with Charisma in her room? And do you see her laying on her bed?
No.
Can I play it?
Is it being offered as an exhibit or just testimony?
She's offering it as an exhibit. It's a video of, I believe, Charisma in her room.
Okay. I just have the sound for it.
Okay, well, that's fine. If she has the sound, that's just nothing. That's half of the evidence that I'm presenting.
Ms. Bell, how about this? Would you be okay with me viewing the video now, and then perhaps after the hearing, you could take it to another computer and see if you can't get it to work?
That's fine, Your Honor.
And then if you have any objections, then you can let me know by the end of the week.
Okay, that works.
Okay. Okay, so Ms. Kuhn's going to show me the video now. And for the time being, Ms. Kuhn, maybe it would help if you could just narrate for Ms. Bell what we're looking at.
I'm going to do it here. I will after.
Okay.
Okay. All right, so Heather, I stopped the video, and it's a video of Charisma laying on her bed in the middle of the afternoon. Her large flat screen TV is on, but I had purposely turned the volume off so that we could hear any sounds that she made. It was an 8-minute video, but I just let it run for, I don't know, a minute or so. Charisma's laying flat on her back, flipping her little teddy bear, which is in her hands every waking moment. And this is evidence of the fact that Charisma is not happiest in her bedroom. The 2005 Behavioral Support Plan stated correctly that Charisma likes being in her bedroom 9 years ago. And then during that time, she was very able and capable of entertaining herself and playing records and loved swinging. Charisma doesn't have that same enjoyment in those things 9 years later. In fact, when left alone in her bedroom, as the judge just witnessed today, Charisma slips into a semi-vegetative state and moans and groans on her back while she flips her teddy bear. Without constant human interaction, that is Charisma's life, and that is Charisma's reality in 2014. And if Susie Larson questioned for 1 second whether a fact so powerful as to state that Charisma is happiest, changing the wording was even remotely true in 2014, I would have been happy to have Susan come over and do a home visit. Susan hasn't been to our home in over 3 years. The difference is remarkable. Charisma was never, in her entire 32 years of life, happiest in her bedroom. And in 2014, it's definitely not true. And I would have been glad to discuss that with her. But she never gave me the chance. If we go to Exhibit C8, this is another OAR violation. C8, excuse me. OAR 411-341-1360, Standards for Monitoring Individual Support Plans for Individuals. And this is in response to Susie Larson not honoring my request to even consult with me about the removal of those statements, or emailing me and saying, no, Renee, I'm not going to replace those statements, or yes, I'm going to. To date, Susie Larson has not removed those false statements about my daughter, therefore that plan remains unsigned. And this OER states, case manager responsibility for monitoring services for the individual. The case manager shall determine whether services are being provided in accordance with IST. That personal, civil, and legal rights of the individual are protected in accordance with this rule, that the satisfaction and desires of the individual's legal representative, or families are addressed. The next violation, OAR, in Exhibit C9, OAR 411-341-1300. The ISP process is critical in determining the individual's and the family's preferences for services and support. The preferences of the individual and family shall serve to guide the team. The individual's active participation and input shall be facilitated through the planning process. The ISP process is designed to identify the types of services and supports necessary to achieve the individual and family's preferences, identify the barriers to providing those preferred services, and develop strategies for reducing barriers. In the 32 years that I have been managing Charisma's care, the only barriers that I have ever come across in being able to support Charisma have been at the hands of Marion County, and this isn't the first time. Exhibit C18. Is Charisma's current ISP. And I'm going to read for you, Your Honor, the rules that we were given when Charisma's mileage benefit first started, and that is letter A. There you go, right there. Charisma requires transportation by her providers to access places and activities in the community. The plan will pay for up to 779 miles per month at a rate of, and that has recently increased, of non-medical transportation. The Oregon Administrative Rules prohibits the use of funds for this program for the reimbursement of medical transportation. So medically related transportation is a service that must be paid for by medical insurance or privately. A mileage log must be kept on the proper county form and submitted at the first of the working day, along with the provider's timesheet. Those were the only rules and guidelines that we were told to follow, and we have followed them without exception. And to date, there hasn't, well, until February 24th, no one made a single complaint or raised a single concern or tried to help guide us or anything else. Exhibit C19H. Okay? And this is Charisma's case plan that I refused to sign. We're going to take a look at what the transportation section looks like in the plan that they wanted me to sign. And that is H. And if you'll notice, Your Honor, in the middle of that, slightly lower than the middle, there's the community transportation section. It outlines the rate per mile that should be paid, up to 360 miles per month, the date that it was supposed to start, the total miles, the plan amount, everything. This is where the mileage reduction appeared for us for the very first time. If you will notice, Your Honor, there are absolutely no notations whatsoever regarding any restrictions or guidelines, including non-reimbursement for medical transportation as required by OAR 411-330-0110, proving that had I signed Charisma's new K plan on February 24th, Marion County would not have cared at all where we took Charisma, how far away we traveled with her, whom we visited, what she did in the community, if she worked on ISP goals, if there were others in the car, whether it was a social benefit or the most effective form of transportation, or any of the accusations that are being brought against us today. Absolutely nothing. The allegations put forth by Heather Bell regarding OARs pertaining to mileage claims, citing OAR 411, 330, 0060, OAR 411, 330, 00602, are referencing mileage logs from February 1st to January 30th. Attempting to disallow these mileage claims from us, Your Honor, is subjective, as they are not based on any cited evidence, research, or information gained from Charisma or her legal guardians. Questions asked to support the social benefit, cost effectiveness, or the availability of any other transportation that may have been available to Charisma. And as such, all of the mileage logs referenced citing violation of OARs are based on hearsay with no supporting evidence, and we, as the claimant, decline inclusion of all of those attempts to disallow mileage. And there was not one attempt to meet with us to gather the truth. Any record of Susan Larson accompanying us on any outing as evidence, or any other factual information to support their false allegations. No one ever asked us. Heather Bell cannot prove that any of these trips did not provide a social benefit, that trips did not relate to her service needs, plans, and goals, or that it benefited someone other than Charisma in the household. We've never logged a single mile with Charisma in the car where she did not enjoy and benefit from being there by working on ISP goals. And we have never even had the thought to bring Charisma somewhere just so we could be reimbursed for the gas to get there. For example, exhibits, claimant's exhibit. Where did that go? Okay, AA1, page 7. And 1. Okay, the entry in exhibit AA1, page 7 reads, on 10-1, claimant was transported to Selco to do her banking and dinner at Kuhn's. For OAR 411-330, this is not allowed by rule because IH funds may not be services, activities, materials, or equipment that are not necessary or cost-effective and do not meet the definition of in-home support social benefits. In addition, trips must be related to recipient service plans, needs, and goals, and are not for the benefits of others in the household, and are provided in the most cost-effective manner that will meet needs specified in the plan. Community transportation services are not used to replace voluntary natural supports, voluntary transportation, and other transportation services. That has been copied and pasted into a lot of them. And I'm going to go ahead and explain what Charisma did on 10-1, where all of those things were used. Charisma was transported that day to do her monthly banking, to have her favorite dinner on the way home from her bank at a local restaurant. Charisma was assessed in 2014 as needing full assist with all aspects of money management as documented in Exhibit C15B. C15B is the part of Charisma's 2014 assessment which verifies that. And it states, under the category of shopping and money management, Charisma, the individual, requires assistance from a person to manage their funds and complete all or most aspects of shopping on their behalf. And it was completed that she needed full assistance with that duty. Charisma has a financial life and does banking at least once a month, and it is her legal right to do so. Charisma was assessed in 2014 as needing full assist with all aspects of transportation. Exhibit C15A. And it states, transportation, Charisma requires full assist. The individual is dependent on full assist from another person for all aspects of transportation, and Susie added a note that said, not able to complete any of these tasks with independence. Because of her level of disability and possible serious behavioral problems towards strangers in the community, there are no other forms of cheaper transportation available to Charisma, and it is her legal right to have her parents transport her anywhere and bill for that mileage if the trip is benefiting her. Having her dinner at a restaurant works on social, behavioral independence, verbal, money management, and other important ISP goals as stated in her ISP plan. Mike Parr, Support Services Coordinator, Offices of Developmental Disabilities, has clarified some very important rules regarding this transportation last week. Exhibit 30A. Reads, "Hi, Mike, I need clarification on the document that you sent to me on page 19 under Community Transportation Needs. This, Gary contacted Mike Parr and said he was preparing for a hearing, and Mike had no problem helping and assisting Gary in answering any questions and clarifying, and this is what resulted. Costs for transporting someone other than the individual with disabilities. Gary asked Mike, does this mean that if we have a family member other than our disabled daughter, like an aunt, an uncle, a sister in the vehicle, costs are to be divided equally based on the number of people in the car, or that we are never allowed to have others in the vehicle if we charge for miles? Mike writes back, no, nothing like that. It means, for example, if you were to go pick up a support worker to work with your disabled family member, the cost of getting the worker to your home isn't an allowable expense. Anyone can be in the car with your daughter. The important thing is that your daughter is in the car. The only time costs are divided is when more than one person is getting a paid services in the car. In other words, if she had a disabled friend and they were getting a mileage benefit, they couldn't both claim the full benefit. So, if your daughter had a friend with a disability who was getting DV services and had transportation in her ISP, then the two plans would each pay for half the cost. Gary said, trips must be related to recipient service plans, needs, and goals, are not found for the benefit of the household. Does this mean that if we take our disabled daughter to a restaurant for dinner, we are not able to eat or to store her or to shop in the store or when she's shopping for her hygiene supplies, we are unable to purchase a tube of toothpaste and put it in the cart too? No. Mike said no. It just means that if you take your daughter with you to get your hair cut, you can't claim the miles just because she was with you in the car, which we have never done once in the 8 months we've been logging miles. Okay. Mike has just documented for us that as long as Chrisma is in the car and benefiting from the trip, anyone can be in the car with her. Mike documented for us that if we were to stop for dinner, that we can eat dinner too, as long as any trip is not exclusively for the benefit of others. Mike's email confirms that the OAR cited by Heather Bell are irrelevant in regards to the 10-1 entry and all other entries based on those irrelevant OARs. We have also proven that we can take Chrisma to Walgreens to buy a tube of toothpaste, and we can throw a tube of toothpaste in the cart that Chrisma has pushed it for ourselves and still be allowed to log miles for that shopping trip. We have proven that when we take Chrisma to see the zoo to see and talk about the animals, that we can take as many people on that outing that Chrisma enjoys spending time with that will legally fit in that car, including Auntie Brenda, her sister, her brother, her aunts, and her uncles and her cousins. To infer it is somehow a violation because others are being transported who are benefiting from the transportation is absurd and not supported by a single OAR. If that were true, it would make it literally impossible for Chrisma to leave her home and use her mileage benefit at all. She can't drive herself anywhere and always requires others in the car to go with her. Any community outing, Your Honor, we take Chrisma on can be construed to be for our enjoyment and benefit, and not hers simply because by disability she is unable to travel outside her home alone. We have proven that any time Chrisma is in the car, regardless if there are other people in the car, it is allowed as long as she is working on ISP goals, which she does without exception. We constantly interact with that girl. We're always getting her to use her words and talking about colors and naming things in the car when we drive. It never stops. We've never stopped in 32 years. Without exception, Your Honor, all outings logged for Chrisma have been for social benefit, opportunity to work on goals clearly stated in both her current ISP and the new plan I didn't sign, and are the cheapest form of transportation available to her based on her level of disability. Heather Bell's evidence is hearsay only and not based on fact ascertained by speaking with us or observing Chrisma on a single outing.
Ms. Kuhn, before you continue, you had mentioned that the OAR cited by Heather Bell, 411-330-0060, was irrelevant. That is the rule in regards to assistance with purchase and in-home support. You had included in that, it looks like C6 for your documents.
Oh, okay. Okay, that was, Okay, Heather put that in, maybe more than one of the items that she was questioning. And those trips, the rule specifically states that the funds cannot pay for specialized food or nutrition essential to the individual. We never use any transportation funds to buy her food.
But these,
Okay.
I'm not questioning, but these are IHS funds.
Yes.
Okay.
Yes. Yes.
Okay, that's what I wanted to
Oh,
clarify.
In Heather's Exhibit AA1, page 7, on entry dated 9/6, it says the claimant was transported to Life Source to purchase special diet foods. And then she quotes her OARs and says this is not allowed by rule. Funds may not pay for health and medical costs that the general public normally must pay for. The transportation funds in no way paid for any sort of dietary foods. Prisma, in her ISP, the current one, the one I didn't sign, all says she needs full support with transportation. We transported her to the store so she could go on shopping, money, managing some goals. She bought pretzels, she bought a pineapple, whatever. No funds were ever used to buy, no transportation funds were ever used to buy any special diet food. I don't know where that came from. Total falsification, a fact. Okay, page 8. AA1, page 8, entry 1016. Claimant was transported to make returns at Ross, shopped at Walgreens, and picked up medications. This is now allowed. She keeps saying it's now allowed in her. It's a constant repetitive thing, and so, but she must mean it's not allowed. But this is not allowed by rule because actions may not pay for health and medical costs to the general public. We didn't use any funds to buy her medications. We don't pay for her medications. Kristen gets all her medicines for free. We logged miles that day, not looking at the thing, but we obviously must have used our miles that day for Kristen to make returns. We shopped at Walgreens. We don't buy our prescriptions at Walgreens. That's not where we get them. And picked up medications at Bi-Mart. We were out running errands for Christmas benefit. No money was ever spent. I don't know how that makes sense. Okay, on page 8, 1015. Okay. Okay. Further down in that, well, actually, this is Disneyland, 1025. That would be on entry 1025. Claimant was transported to the airport to go to Disneyland. For OAR 411-330-006, this is not allowed by the rule because vacation costs for transportation, food, shelter, and entertainment that are normally incurred by a person on vacation are not strictly required, on and on and on. Okay, Mike, Mike Parr in his email, wherever that went, told us that if Prisma requires transportation to get around in a hometown, to go to Ross, to go to Walgreens, whatever, she also requires that transportation to get her to the airport to go on vacation. We didn't ask anybody to pay for vacation costs. He said if she has the benefit, here it is. Here's what he stated. It's C26, Your Honor. Evidence C26. I take it to mean that being on vacation cannot cause someone to need supports that they wouldn't need if they weren't on vacation. I can't come up with a plausible example off the top of my head, Mike says, but as an illustration, an individual who is demonstrably able to complete personal hygiene at home cannot be said to need support with personal hygiene when traveling. Prisma needs the support with transportation at home, and she needed it to go to the airport to go to Disneyland. We never billed for any transportation in Disneyland. But according to Mike Parr, we have the legal right, if she requires transportation, she can have it when we take her to Disneyland. And entry on page 10, Your Honor. these are the falsifications that I vehemently will not accept. Interpretations are entirely wrong, and facts are misstated. AA1, page 10, entry 12.3. It says here that claimant was transported to Rhodes to get supplies for painting for a painting project in the kitchen. This is not allowed by rule, on and on and on and on. Buying paint to remodel the family kitchen has no social benefit to claimant. It is a benefit for another family member. Your Honor, if somebody wants to pull out pull it out. December 3rd. This is what's happened in all of the mileage laws that we have done. Heather read what I wrote. What I wrote is went to Rada to get supplies for painting project in kitchen and looked at Christmas lights after dinner. From that, Heather got that we were remodeling the house, that I was working on painting the kitchen, and it was not for Christmas benefit. The truth of the matter is that I gave Christmas in November a $3,000 budget to create a massive structural learning experience opportunity where she got to completely do a makeover on her bedroom. Everything, her and I sorted everything. We decided what would go to Goodwill and what would be sold. We went shopping for 4 months for everything from floor to ceiling except for her flat screen TV. Our trip to Rada that day was we went to buy paint for a vintage chandelier that Charisma and I were repainting and was going to be installed in her bedroom makeover as part of the structured learning experience. No way in there did I say that this was a remodel where Heather states for another, buying paint to remodel the family kitchen. I cannot paint the chandelier on the carpet in Charisma's bedroom. The chandelier itself was brought into the kitchen. That's where I put down tarps. That's where Chrissy can stand and access that much more easily than if I'm like sitting on the carpet and trying to paint something. That's what's happened in many of these laws. Okay?
I'm sorry for interrupting you, Ms. Kuhn, but Ms. Bell, it appears we're getting close to noon, and I'm sure your schedule is pretty full.
It is. I have a 1 o'clock.
Yeah, and I think you have a bit more to say. Correct, Ms. Kuhn?
Yes, Your Honor, I do.
Did we go to 1?
Well, we're state employees. We're required to take the hour lunch.
I know, but I mean just for another 10 or 15 minutes.
Oh, yeah, we should go till noon.
That's what I need. Okay,
sure.
Okay.
And we could continue another day at that
We need to
time.
continue. I don't think we need to. Okay. So no, we're just about done.
I think we need to continue because I have some questions.
Okay. 2 more minutes.
Yeah.
Yeah. Why don't let's go another 5 minutes and then try to wrap up for the day.
Are you going to give Heather an opportunity to?
Yeah, I think that's what Heather's point is, that she's going to have some questions, and we just won't be able to wrap up today by noon.
Okay. Let's see.
So maybe just find a good ending point.
Okay. Well, here, this is a big one. Heather states in numerous entries that Charisma's sister was in the car when my mileage law doesn't state that at all. And there were numerous ones. Over and over again, where it was just kind of a cut and paste deal that she pasted in. These are them right here. Exhibit AA1, page 14, entry 121. She says, in addition, claimant's sister benefited from the transportation. There was no sister stated in the vehicle. Entry 122, in addition, claimant's sister benefited from the transportation. False, no sister. Entry 124, claimant's sister benefited from the transportation. Sister was not in the car. We were in the car that day, and we went up to pick up her puppy and brought the puppy back home for Christmas to play with. The sister was not in the car. And I could go on and on and on about the falsifications and incorrect information that appear in the things that, and there are 2 more. On AA1, page 15, entry 127, Heather again states that the sister was in the car and benefited from the transportation. No sister stated on my mileage law. Again, that happened on 130. And I'm done. I do want to make a closing statement, so.
We're going to just have to continue this to another day.
Okay.
And I don't have my calendar in front of me, but it's usually pretty full for the next 3 weeks or so. Do you folks know your availability in general? We may be looking at June, quite frankly.
So then what happens, because I didn't sign Christmas plans, and that, I don't know.
I was wondering that myself, but
I don't know
that's
anything
nothing
about
that-
this. This is the first time I've ever done a hearing. I don't know. What, honey? Will Heather need more than 10 minutes to ask her questions, and then we can be done?
Yes.
Ms. Bell, do you anticipate that your cross-examination may last longer than 10 minutes?
It could, yes.
Okay.
As well as I may put on witnesses for rebuttal as well.
Okay. Yeah, well, I don't see any other option but continuing for another day. And are there certain days that work better for you folks?
Well, we can. We're going to take her to the end of May for 3 days, and other than that, I don't have my calendar, but do you have a date that you could offer?
I'm going to go look at my calendar. I'm anticipating it's probably not going to be until the beginning of June.
And will her benefits on her current plan carry over until this issue has been resolved, or how does
I don't have that answer. They want to contact the department in regards to that. So, Ms. Bell and Ms. Forrest and Ms. Larson, if you want to have your calendars ready, I'm going to step out of the room for one moment and grab my calendar. I'll be right back.
Okay.
Christmas is set to expire on June 30th. So that's the date.
I'll be right back. Okay, this is Eric DeLuge. I'm back with my calendar. Are you there, Ms. Bell?
Yes, Your Honor.
Okay. Looks like in June, the only days that I don't have available right now would be Monday, June 2nd, and Tuesday, June 10th. Other than that, my calendar is available. So I'll start with Mr. and Mrs. Kuhn. What?
Gary's checking his calendar right now. We'll base it on his calendar.
June 3rd would be acceptable.
How about
That
the
works
other days?
for me, this is Susan Larson.
June 3rd. And how about you, Ms. Forrest?
That works in the morning.
And Ms. Larson, would June 3rd work for you?
Yes, it would.
Okay. So why don't we continue this hearing then on June 3rd at 9 a.m. And Mr. and Mrs. Kuhn, did you want to do in person, or do you want to finish this up over the telephone? In person, okay. You get back on June 2nd?
Yes.
Are you sure you want to do it, come in on the 3rd? Okay, so, yeah. When we resume, we'll resume with Mrs. Kuhn's testimony, and then Ms. Bell will have the opportunity to question you, and it seems like she may have some other witnesses she may intend on calling.
So what are the rules that guide this now? We submitted our evidence, so that can't change. They can't change, we can't change, or what do I need to know? Still bring in evidence?
You could bring in evidence and give it to me, but Ms. Bell will have the opportunity to object because of the timing of it, but Ms. Bell may not object, so it'd be helpful to provide that as soon as possible, so if there's anything else.
And then if I provide that, I have to let her.
Yeah, anything that you want to submit, you have to provide a copy to Ms. Bell.
But we can bring in other witnesses if we choose as well.
At this point, it's only rebuttal, so anything that would directly rebut anything the department has said during its testimony. So that's when Heather Bell mentioned that she may have some rebuttal witnesses. Those would be called to challenge anything that you or Mr. Kuhn have testified to so far.
Okay.
And Ms. Bell, do you have any questions?
No, Your Honor.
Hey, anything further from the department?
Not at this time.
Okay, that will conclude our hearing for the morning, and like I said, we'll continue on June 3rd at 9 a.m. Thank you, everyone. Goodbye.